Now, you also talked about stippling and soot, correct?
Yes, that's correct.
Stippling and soot, you said, can be an indicator. First of all, you said as to what is an entrance wound. It can also give you some idea of distance. Would that be fair to say?
Only when there are no intermediary targets.
Okay, and I understand. Generally, one would expect to find soot and stippling if the shooter, or not the shooter, but the end of the barrel, the muzzle, is within 2 feet or less of the person that's being shot. Is that correct?
It depends on the gun. There are ranges for various guns, and that's what test firing is for.
Okay. Would it be fair to say that beyond a certain range that you would not expect to find soot and stippling? Is that correct?
That is correct.
Even if there weren't any intervening obstacles, is that fair?
That's correct.
And how is that generally described?
It depends on the gun, and it depends on the gunpowder, and it depends on the type of ammunition.
Okay. And would it be fair that generally speaking, within 2 feet for most guns and most ammunition, that you would expect to find some type of soot or stippling if there were not any obstacles between the muzzle and the person being shot, or the surface?
Would that gun have a silencer, or would that gun have been modified in any way? And what are some of the other conditions?
Okay. Absent anything like that, would that generally be fair to say within under 2 feet, 2 feet or under?
In many guns, yes, you would see that.
Okay. All right. And by the time that you went out and took a look at this Durango yourself, it had been in the custody of the Jacksonville Sheriff's Office for approximately a year and a half. Would that be fair to say? And I might be off by a month or two, but I'm just saying approximately.
Yeah, not knowing when it entered into that. I mean, so if you're saying a year and a half out from the date of the incident, yes.
Okay. And at the time that you went out and examined the Durango, you didn't do any examination of the exterior of the vehicle for any sign of soot and stippling then, correct?
That's not part of my autopsy, no.
Sure. And, ma'am, you did, in fact, give prior testimony as to your opinion as to Mr. Davis's position in another date. Is that correct?
That's correct.
Okay. And that based on questioning within that prior testimony and other information, you decided to go to the scene, not the scene, to the JSO warehouse to explore possibilities. Would that be fair to say?
That's correct.
And that's when you went out on May 12th of this year to explore those other possibilities. Is that fair to say?
That's correct.
And in going back out there on May 12th to explore other possibilities, you confirmed your own opinion to yourself. Is that correct?
What I saw was consistent with my original opinion and helped me understand better that other possibilities were not plausible in my opinion.
That would be a yes, ma'am, to my question.
Yes.
I have nothing further, Your Honor.
Ms. Corey.
Dr. Simons, tell the jury why that would be a yes.
So, I think it's really important to stress the fact that if other information is presented, I would like to make sure that all possibilities are examined. And so by, as we've just mentioned, discussing what's plausible from a common sense point of view, with the door open, a door closed, a door partially ajar, I felt that it was important to explore all of those. And there's a difference between confirming my own suspicion by going in with a closed mind and not fully exploring, and fully exploring all the possibilities to my satisfaction and saying, wow, okay, there was nothing else that could explain it as well as this scenario. And so.
Did your personal visit to the vehicle strengthen your opinion that Jordan Davis was seated inside the vehicle at the time he was shot?
Yes, it did.
Okay. Dr. Simons, based on some of the questions that defense counsel asked you, if the door was open and Jordan Davis's legs were outside of the car in any way, wouldn't he have had to be sort of flying through the air to sustain the 2 gunshot wounds that came in underneath his buttocks?
Yeah, in my opinion, the legs would have needed to have been probably, up off the ground, but in a series of movements that I don't see being plausible.
And Dr. Simons, if testimony was presented in this case that the car immediately was put in reverse when the shots started firing, would Jordan Davis have been able to maneuver himself after being shot by jumping into the vehicle, closing the door, and getting back into a seated position?
I don't believe so, no.
Okay. Are the abrasions to Jordan Davis's body consistent with him being dragged out and laid on cement while life-saving efforts were going on?
That's a possibility, and they're non-specific abrasions. For example, the scrape on the forehead, there was no underlying injury when I did my examination of the scalp and the skull and the brain. So it was a minor superficial injury, and there's just no way to know what they're from.
Thank you. May I have just a moment, Your Honor? The state has no further questions of Dr. Simons.
May she be excused?
She may.
Ms. Anthony?
Well, Judge, I think subject to
Subject to
recall,
recall.
we'll
All right,
discuss it
thank
there.
you,
Yes,
Doctor.
sir.
Okay.
State's next witness.
The state of Florida rests its case, Your Honor.
Ladies and gentlemen, the state of Florida has rested their case, but we are not finished as, Doctor, you can go right ahead, I'm sorry. But we are not finished, so I will give you a lunch break. I have to talk to the lawyers about a variety of matters while you're at lunch. Again, it's not time to form fixed opinions, not time to begin discussing the case among yourselves or let anybody approach you or anything of that nature. We're still in the same posture that we have been, and we will continue to be in that posture until I actually read to you the jury instructions that will apply in this case, whenever that may be. So I say all that, and it is now almost 20 minutes of 1, so we'll give you until 20 minutes of 2 for lunch, and we'll see you back then. Thank you all very much for your time and attention. Ms. Hannah. Mr. Carlisle.
Your Honor, at this time, the defense will move for a judgment of acquittal as to the issue of premeditation. The case law is pretty clear as to premeditation. There's no set time for premeditation, and the issue of premeditation is usually one to be left for the jury. However, the case law also stands for the proposition that premeditation, to be legally sufficient, must be proven beyond a reasonable doubt. That's very fact-intensive, so my argument will be based on the facts that we've heard in this case. Ms. Rower testified that Mr. Dunn was happy that day, that they had a good time at the wedding, that he was happy leaving the wedding, and that he was mildly annoyed at hearing this loud music. So the time for premeditation would start as he's parked at the gate station with Ms. Rower inside. The confrontation, Mr. Dunn asked the guys to turn down the music. And
Close that door, please. I'm sorry. Go ahead.
Mr. Dunn, and I'm stating all these facts in the light most favorable to the state, as is the standard. Mr. Dunn asked them to turn down the music. Tevin Thompson does. Jordan Davis immediately begins to escalate the situation. The testimony was that there was some argument back and forth. And I want to focus on the first 3 shots because of Dr. Simon's testimony that these 3 shots were the shots that killed Jordan Davis. There was conflicting testimony as to what was said right before the shots. There was some testimony that Mr. Dunn said, "Are you talking to me?" Other testimony that you're not going to talk to me that way. Within a matter of seconds, Mr. Dunn grabs his gun from the glove box, turns and steadies himself with his hands on the windowsill, as testified by I believe it was Miss Grimes from the gate station, and fires those first 3 shots, all within a matter of about a second. Leland Brunson testified that Mr. Dunn cocked the gun. Tevin Thompson did not testify to that. Mr. Smith did not testify to that, so it's kind of conflicting on whether he cocked the gun or not. There's no evidence that the safety on this firearm was on at the time. There's no evidence that Mr. Dunn said anything before turning and firing from a seated position inside the car with the door closed. The evidence suggests that Jordan Davis escalated this interaction with his words and gestures, and even Leland Brunson said that Jordan Davis tried to get out of the truck but couldn't because of the child locks, which we know is not true because we've seen pictures that the child locks were not engaged. And although the guys in the car wouldn't admit to hearing the threats, they did agree that Mr. Davis was the one escalating the situation, and Mr. Dunn acted immediately and instinctively to that escalation. So we would argue that there has been not enough evidence of premeditation in this case, and that would be our argument as to judgment of acquittal, just to the issue of premeditation.
All right. Any other arguments as to judgment of acquittal for any other reason or?
No, Your Honor.
Okay. Ms. Corey?
Your Honor, the evidence taken in light most favorable to the state more than substantially demonstrates that this defendant pulled out a semi-automatic weapon, pointed it directly at Jordan Davis, and shot 10 times into the vehicle in which he was sitting, meaning he had a specific intent to kill. Because there is no time limit on it, the evidence is abundantly clear that he had sufficient time to make a conscious decision to kill and then proceed to pull the trigger, which he knew would result in the death of a human being. That's all that's required for premeditation.
All right. The gun prior to their arriving at they, meaning the defendant and Ms. Rauer, arriving at the Gate gas station. But in the light most favorable to the state, it could be argued it began with the remark, "You're not going to talk to me like that," or whatever it was along those lines. And then the actions of actually leaning over, opening a glove box, removing a firearm, removing it from a holster, racking the gun, turning oneself, pointing and firing. So in the light most favorable to the state, I believe they have proven or presented prima facie evidence that would warrant presenting the case to the jury for the charge of first-degree murder. So the motion for judgment of acquittal is denied. We will begin, as I'm to understand, with the defense's case, because you intend on presenting witnesses. Am I correct on that, Ms. Hanania?
That's correct.
And we'll begin with that when we come back from our break, and we'll see where we go from there as far as the remainder of the day. Anything else from the state?
No, sir.
Anything else from the defense before our break?
No, sir.
All right, then we'll be recessed till 20 minutes of 1.